Hey everybody, it's Tracy, and I wanted to talk about the regulation or lack thereof of liquidity pools. And liquidity pools are an absolutely essential component of the DeFi landscape because the concept is to, as the name would imply, provide liquidity, right? You contribute a token coin to the liquidity pool, and then that liquidity pool serves to facilitate trading on a decentralized exchange, or DEX. And even when you look at, right, centralized exchanges, the largest ones, and think of like Bitcoin, Ethereum, the largest traded crypto, it's actually a very illiquid market when you compare it to traditional equity markets, right? Like Apple, Microsoft, whatever. The liquidity is wild, right? Compared to what crypto is. And the farther you go down the rung in terms of popularity, the less liquid it gets. That's why you see such wide swings in prices in crypto. But when you get to the decentralized exchange, of which there are fewer participants and less interest and less understanding, the illiquidity gets even greater. So liquidity pools fill that void because they ultimately act as like a market maker and match trades. So you can go on and anticipate that your trade will be filled. So your benefit as a contributor or a participant in liquidity pools, obviously you contribute the crypto, the token, the coin, and then you earn some pro rata share of the trading fees earned by the DEX. Great. So when you think of the regulation, the initial answer is there is none, right? Because if there's one area of digital assets that regulators are sort of behind at, and I think they're behind in everything, the father's behind in DeFi because there's so many questions, right? And it's really like a 3-level analysis, right? So first you look at securities laws. And just on a basic concept, right? I participate in a liquidity pool. I get a pro rata return, right, for my token that insures or entitles me to that return. That looks like some kind of collective investment scheme, right? Or at a minimum, a contract for yield, right? Which is a security. Now, the argument says if it's truly decentralized, right, and there are no common management, which most decentralized platforms are, does it fall out of the first rung of the Howey test? I would argue yes, but that hasn't been proven anywhere, right? And the tenor and approach of regulators thus far has been to litigate as a means with which to set law, as opposed to the millions of other countries that have literally just created frameworks, right? Countries that you've never even heard of. Like I spoke about Anguilla yesterday. They have a great ICO framework. We don't, right? Why? But that's another story for another time. You look at these things and you go, okay, fine. Here's what's coming potentially, right? And on the liquidity pool, first thing I look at is that the sale of a security, right? Your investment, if you will, into the liquidity pool, which would trigger such things as like accredited investor limitations, the potential to have to register that security, which the SEC has said, come in and register, but no one knows how to do that, and they're not really going to allow you to register in the first place. It's a bait and switch. But that's something to think about long term because that may be the ultimate outcome. Second level of analysis is money loss, like money service business, money transmission, and the like, right? And you look at FinCEN because the definition of money transmitter and the amount of guidance that FinCEN has provided versus really any other state or any state or all the states combined would arguably place a liquidity pool or define a liquidity pool as a money transmitter, which would require money service business registration. And as I've talked about a million times here, money service business registration, while very simple, straightforward, carries with it an obligation to comply with Bank Secrecy Act regulation, which is another name for the United States AML KYC rules, right? So if you assume that, as opposed to what the norm is for liquidity pools, of which there are many, your participation in that would be subject to AML KYC checks and then ongoing compliance, like transactional monitoring, the whole gamut, and suspicious activity reports and all that kind of stuff. which you just don't see liquidity pools doing, because conceptually, for the liquidity pool to work and actually offer the returns that make people want to part with their crypto is the fact that they run at a very low cost, right? And when you add in compliance that relates to like running a liquidity pool, then they have to push that to the DEX. Those fees get higher, less people use them, and you go on the way. Not to mention the fact that a lot of people in DeFi just aren't going to want to give KYC, no matter what you're really like. They just don't want to do it, right? And that's anecdotal, but it's sort of the way of the world. And the fact that the decentralization argument may work in a securities context, it may not work and probably doesn't have any bearing on the money service business delineation, right? And then finally, you have like the state level, right, in the United States. Conceptually, does a liquidity pool have an obligation to become licensed as a money transmitter in exchange? I would argue that the DEX would, conceivably, but the liquidity pool itself, I don't think there's an argument, with the exception of like New York, which the BIT license basically says if you do anything related to crypto, you have to license, right? But you simply don't manage the pool from New York. Maybe you don't accept investors from New York, right? But outside that, I don't see any state regulation that would really apply to it. At a minimum, I think what's clear, money service business registration, although nobody's doing it. Second, you have, I think, an impending wave, if you will, that's coming about securities compliance, which is going to drastically limit the ability of who can be a participant in the liquidity pool. You're talking having to do offering memorandums, accredited investor checks, this whole 9 yards. And then state level, I don't think there's anything else, right? It's great and it's absolutely essential. And right now, you just don't see the regulation. But I think long term, and this could be within a year, I think you're going to see more regulation. So how you sort of prepare for that, it's tough, because I think if you're Sushi Swap or Curve, any of these, you're going to put yourself at a competitive disadvantage if you start thinking proactively, right? And this is just my guess, but I think ultimately regulation's coming, and it's going to come on those particular two areas. States could follow New York's lead, but right now. Are there any questions on liquidity pools, formation, structure, regulation, anything like that? Definitely hit me up, Adam at adamtracy.io, and I'll talk to you next time. Cheers.